Somebody asked me the other day, Angela, can I register a descriptive trademark if I spell it differently? Well, no, you can't. And that's what I'm going to talk about here in the next 4 minutes. I'm Angela Langlotz, trademark and copyright attorney, and I go live here on weekdays to talk trademarks and copyrights. So many of you are coming to me to register descriptive trademarks, and those are really, really hard to register unless you've been using them for more than 5 years. So sometimes people will come to me with a new brand and they'll say, Angela, I want to register this trademark. And I'll say, how long have you been using it? And they say, I haven't used it yet. It's a brand new business. And I give them the bad news that descriptive marks are not registrable if you haven't been using them for a while. So I wanted to do a case study. I saw something the other day that I thought would make an excellent case study. So let me give you some background. There is a rule in trademark land that you cannot register descriptive trademarks. Now, why is that? Now, remember that the whole point of trademark law is to distinguish your goods and services from other people's goods and services. And in order to do that, your trademark needs to be distinctive and not descriptive of your goods. So we don't want to prevent, by giving you a trademark, which is the exclusive right to use certain words or phrases or symbols in conjunction with the sale of your goods. We don't want to give you the exclusive right to descriptive terms because it would prevent other people from fairly describing their goods and services. So I ran across an example the other day that I thought was a good case study, and I want to show you that now. So I ran across this business, and I'm going to show you, switch the screen here. I was driving down the freeway and I saw, if you look up here in the upper left-hand corner, I saw this business. It was called OTTO SOURCE, except they spelled auto, O-T-T-O. Now, auto, O-T-T-O, sounds like A-U-T-O, auto, right? Auto, OTTO SOURCE. So if we were, now these people haven't applied for a trademark, they're not my clients, I'm just using them as a case study. So what would happen if the OTTO SOURCE, O-T-T-O people applied to register OTTO SOURCE for automobile sales? That mark, unless they've been using it for more than 5 years, and therefore it had acquired some distinctiveness in the marketplace. But let's set that aside. We're just talking broad principles here. There's always exceptions to rules, and I'm not going to talk about the exception. But here's the rule. You can't register a mark that is merely descriptive of the goods. So if you are selling automobiles and you want to register a mark like OTTO SOURCE, in other words, you are a source for automobiles, that is likely going to be refused registration for being merely descriptive. It's descriptive because it sounds like the word auto, O-T-T-O, sounds like auto, A-U-T-O. And so if we give that applicant the right to use OTTO SOURCE, O-T-T-O, it would prevent other people, because of the way trademarks are considered. We consider the overall impression of the brand, not only the way it's spelled, but the way it sounds. The way it sounds is part of the commercial impression that the consumer gets when they're confronted with your brand. They hear it, right? So you hear auto and you think, oh, OTTO SOURCE, right? So if we give auto, O-T-T-O, source, the right to the exclusive brand, to the exclusive use of the brand OTTO SOURCE, it would prevent anybody else, because a trademark, remember, is a monopoly, it would prevent anybody else from using that brand, that mark, to describe their goods, to be a source for automobiles. So that's why we can't register descriptive marks, because we don't want to give someone the exclusive right to say that they sell autos, they are a source for autos. So remember that a descriptive mark is any mark that describes the goods, the end user of the goods, the use to which the goods are put, or it's basically anything that gives an idea of what the goods are just by looking at the mark. Okay, so don't use descriptive marks. Descriptive marks are almost impossible to register unless you've been using them for a very long time, more than 5 years. And the more descriptive the mark is, the longer you're going to have to be using it in order to get it registered. Those are the rules. I'm Angela Langlotz. You can find me online at TrademarkDoctor.net. I have a huge library of videos on YouTube. Just go to YouTube and search Trademark Doctor. If you have trademark questions, I would be happy to answer those. Just drop your question in the comments below. Like and subscribe to get more of my videos. And let me know what questions you have. I will answer them on a future live video.